I'm here with Patrick Salvi. Mr. Salvi is an established personal injury trial lawyer in Chicago. He began his career there starting in kind of an all practice situation. He started in a little bit of criminal defense, a little bit of family law, and a little bit of personal injury. And then he grew his firm into one of the most successful trial firms in the United States. Recently, he won a $148 million settlement, which was the largest verdict for compensatory damages in the state of Illinois. And his son, who is practicing law at his father's firm, Patrick Salvi Jr. or Patrick Salvi II, has his own record of success and is following in the footsteps of his father. And Mr. Salvi, it really is a pleasure to have you with me.
Well, pleasure to be on your show, Austin.
Yeah, absolutely. So can you start by telling us a little bit about your background, how you got started, how you got interested in trial law, and maybe where you started at the University of Notre Dame?
Sure. So I graduated law school at Notre Dame in 1978. My father was a general practitioner in Lake Zurich, Illinois, and I joined him and worked with him for 3 years. And I think, as you mentioned, the introduction, I did a little bit of everything, which is what general practitioners did back then: criminal, probate, divorce, real estate, and some personal injury. And I really enjoyed personal injury work. I wanted to be in the courtroom. I enjoyed my criminal law experience, except that at least it was my experience that most of my clients were criminals. Not all, as we know, some are wrongfully accused, too many in fact, but that was just not a practice that I wanted to do full time. I admire criminal defense lawyers immensely, but I really developed an affection for personal injury trial work. I really felt as if I could truly help people, really change their lives, give them hope. You got to remember, when they come to see me, it involves usually some devastating, catastrophic nightmare that has befallen them, and we give them hope, and then hopefully the financial means to overcome it. And I built my practice starting in January of 1982, all by myself. Small office in Waukegan, and just had the good fortune of some settlements and verdicts. I was one of the few lawyers, especially in our community, that was willing to handle medical malpractice cases. The theory being back in the day that you don't do med mal because you'll antagonize the medical profession in terms of their testifying in your personal injury cases. And, I really think that was a flawed sort of analysis. And frankly, medical malpractice cases, although they're tougher, they're riskier, they're more expensive. They involve usually defendants that, if you do have a case, have the wherewithal to fully and fairly compensate your clients, unlike a lot of terrible automobile accident cases. So, and it's just, really the medical malpractice field in the early 80s and in the 90s really took off, and that was a very big boost to my practice as well. And, began adding lawyers, and, eventually realized, in as much as I love practicing in Lake County, Illinois, in order to compete with the best, for the best cases, I had to be in Chicago. And now we're essentially considered a Chicago firm that happens to have an office in Waukegan. I have 18 lawyers, all terrific trial lawyers in their own rights, and one of whom, as you were nice enough to mention, my son, Patrick. I also have a son, Brian, who's been with me since 2013, another Notre Dame law grad. In fact,
Football player,
he's
right?
very obnoxious. That was my son, Chris, not a lawyer.
Oh, okay.
Brian is what we call a double domer, and Notre Dame alum will know that means, you do undergrad and then some graduate degree, in Brian's case, a law degree at Notre Dame. And so Patrick and I have tried 9 jury trials together. Brian and I probably about 4 or 5. And of course, it's a great thrill to go to verdict, especially with your sons. And knock on wood, we've they've been successful, so that helps.
That's excellent. I wanted to address a few of the things that you said there. First of all, you talk about the serious nature of your client's circumstances. If they've gotten to you, they really have experienced something terrible, catastrophic injuries. How is it that, because, and I don't know your personal history, and maybe you have something in your background that would help you relate to people with catastrophic injuries. I'm not sure if you do, but how do you try to understand them as people and try to really understand what they're going through? Like starting from when they get out of bed in the morning and like maybe they can't get out of bed in the morning and going to their daily lives and each little challenge that they face, in addition to the obvious challenges of something like complex regional pain syndrome or things like that. How do you kind of get into their shoes so that you can best tell their story to the jury?
Well, that's a good question. I think number one, in order to be an effective personal injury trial lawyer, you must possess the necessary empathy for your clients. But by the same token, you can't be commiserating with them and be so down and out about what's happened to them that you lose professional judgment. So it's a balance. I truly am empathetic, but I'm not, I'm not crying on their shoulders with them. My role, as I see it, is to, number one, have dogged preparation with regards to the investigation of their case. And if it's a meritorious one, then that dogged preparation is with regards to the prosecution of their case. And I tell them, I'm going to help you. we know what we're doing. We're going to take care of things. Now, you can't provide absolute guarantees, but if I accept a case, I'm confident that by either settlement or verdict, and we prepare as if it's going to trial always, that I am going to prevail and going to help them. And there's a great deal of comfort it goes to a client who knows the lawyer means what he says. When he says, I am going to take care of, we're going to take care of you. This is going to work out. And so that's a great reassurance. And then of course you have to fulfill that promise, and we do. And so you have to get to know the client and the struggles. Everyone is different. Every condition is different, but by and large, I'm handling cases that involve a brain damage, a spinal cord injury, loss of limb or limbs, or some very tragic, catastrophic type injury that really interferes with their day-to-day function, their ability to work, and usually involves a significant aspect of chronic pain. And then, you need to persuade them that money compensation is appropriate. It is the cornerstone to our civil justice system. And that involves not only economic damages, that's easy, medical bills, past and future, all those go to healthcare providers. That really doesn't go to the plaintiff. Those are just given to the plaintiff so the plaintiff can then turn them over to the healthcare provider. The real important things are pain and suffering, loss of a normal life, disfigurement, emotional distress, things of that nature. So my job is to select jurors that are open to those elements of compensation and will deliver a verdict that is commensurate with the suffering of the plaintiff by today's dollars and what reasonably can be expected 10, 20, 30, 40, 50 years, depending on how old your plaintiff is and how long they're going to suffer and how badly.
Yes, sir. Yes, sir. I was, when I was young, I would say 12 years old. I was in a serious car accident. We were T-boned at an intersection, and my mom was a nurse, and my grandma was there as well. And we at the time just didn't know that we should have gotten a lawyer for that, and so we dealt with the insurance company, and we got a settlement that was not commensurate with the damage that all of us suffered. And it's important, I think, for ordinary people who may be watching this to know how deceptive insurance companies are, that it's in their interest to keep settlements low, and how important it is to have an advocate who's competent, who will do the requisite investigation, as you've discussed, and who will tackle the case professionally. And as you said, pick a jury who is willing to award the kinds of damages that they're suffering from: pain and suffering, loss of a normal life, things of that nature. Let me ask you, with regard to jury selection, what have you found about Illinois juries? And I know that that's super general, because you're picking a jury in Lake County might be different, or in Peoria might be different than picking a jury in Chicago. Not might be, it is. What would you say, I guess, about Chicago juries and then juries elsewhere in Illinois? What would you say their position is on the kinds of damages they're willing to give to plaintiffs?
Well, I mean, there's no question that there is a difference, generally speaking, with regards to awards in Cook County, Illinois, versus certainly outlying counties and particularly downstate counties. That said, I have noticed that even in relatively considered to be very conservative venues, if you have a compelling case with substantial damages, pain and suffering, disabilities that affect the ability to function, certainly work, etc. Even in conservative venues, where we hold many records, they will award substantial damages. Now, you have to do your job in terms of jury selection. There are certain folks that, and they're not bad people. They just don't think, no matter what the evidence is, they simply could not award more than $1 million or $5 million or $10 million, regardless as to what the evidence in the law might be. And so my job is to identify those jurors with a candid voir dire, and to deselect them, and hopefully end up with most or all the jurors being at least open-minded with regards to especially non-economic damages in substantial amounts, many, many millions of dollars each for each element, assuming the law and the evidence supports that. And, it's even in conservative jurisdiction, they're exposed to media and all of the social media, et cetera. And so they're not shy about awarding substantial damages if it's deserved. In fact, in one of my favorite rebuttal arguments, when a defense lawyer gets up and talks to a Winnebago County or Jefferson County or McHenry County, or you name your outlying counties or downstate counties, how outrageous Mr. Salvi's suggestion is, I quite honestly say to them, you should be insulted by that. He's really saying that, that's a lot of money for people in Winnebago County. That's insulting. you know, when we picked you as jurors, we talked to you, we said that if the law and the evidence supports a verdict of $15 million, could you sign such a verdict? And I think each of you said that you could, and you would. And haven't we proven that to you? And more often than not, I see a lot of nods of the head. And that's a good sign that they're like, yeah, you know what? We did. Admittedly, they came into the courtroom on Monday morning thinking, not even thinking under any circumstance would they be signing a verdict for $15 million. And sure enough, they ended up doing that. And but in Cook County, you know, assuming you have strong cases, you know, that's where you see almost on a weekly basis, 10, 15, 20, 30, 40, $50 million verdicts. And, you know, part of it is the makeup of the veneer, and part of it is, you know, there's so many more cases that go to trial. You know, I have to say to many downstate judges, you know, where the judge will say, Mr. Salvi, you know, the biggest verdict in our county is $350,000, and they're offering you $2 million. You know, I say, Judge, listen, with all due respect, I know what I'm doing, and so now you have to produce. You have to know that you can deliver the goods, and but I know that. I know from the case. I know from my preparation. That I'm going to deliver the goods, and if I get a halfway open, decent, open-minded group, the verdict is going to be a good one.
I think that's remarkably clever. That they're saying the defense is saying that's too much money for somebody in Winnebago County. It appeals to the rural respectability, which I'm very familiar with, having lived in Wyoming my whole life. I think that there is a sense that conservative jurors like to follow the rules, and they like to keep their word. And if they've given you their word, and you can hold them to that, or you can not hold them to it, but remind them of it, then they will follow the rules. And that there is a lawyer out of California by the name of Rex Paris. I'm not sure if you've heard of Mr. Paris,
Sure.
but
Yes.
he said the same thing. He's a Republican mayor of a small town in California as well. And he has said the same thing, that conservatives like to follow rules. And if they've given you their word in jury selection, you can take it to the bank, because it's that kind of integrity is very important. Not saying it's not important for people who are more liberal or left leaning. It certainly is, but they have a particular proclivity for that, and it's very important to appeal to. It's very clever. Let me ask you, I know that you're a fan of David Ball on damages, which is a great text. I'm curious though about your larger reading list. I know that you say that you refer to some classic texts on the eve of a big trial to remind yourself of the smaller, subtler, more specific strategies that those texts advise. What can you give me a list of those texts? I would like to read them.
Yeah, you know what? I don't really have one. Friedman, I read. David
Friedman?
Ball, as you mentioned, and I really have just over the years, I really am an avid reader of the lawyers who admire closing arguments, and then I like to plagiarize, handpick, you know, certain phrases, certain arguments, certain rebuttal arguments. And I like to think now, you know, a lot of people read mine, and they're nice enough to tell me, oh, I borrowed this, I borrowed that. I said, well, I probably borrowed it from somebody else, so you know, don't feel guilty. But I really don't have a big laundry list of, oh, this is my go-to. I really have just sort of accumulated over the years based on, you know, some text, but more on learning by reading some of the masters, voir dire and closing arguments. and other kind of trial tactics, and incorporate that in my trial practice.
That's excellent. Yeah, I'm a fan of Rick Friedman as well, obviously, and I will certainly, if you could send me any of your closing arguments that you have, I would be most appreciative. I am looking for anything I can get my hands on regarding personal injury that will help me in the practice of law. And if you give me permission, I'd be happy to share them to larger channels as well, if you'd be comfortable. I know
I'd be
that.
happy to do that.
Yeah, I was going to say, I know that defense attorneys are always watching, but then again, they can order the transcripts, and they do. I've heard Mark Lanier say that they frequently order his transcripts. They try to preempt his analogies, not that it ever works, but yeah, they're out for blood. And with that, I wanted to ask you, a lot of people that I've talked to, a lot of personal injury lawyers of some repute have all told me that the insurance companies, if not their lawyers, then certainly the companies themselves, can act like bullies. How do you deal with bullies?
Yeah, I mean, in terms of how I kind of handle my opponent or opponents, I really don't, I certainly take into account their style. I read up on, their little tricks of the trade, more to, maybe craft motions in limine to prevent any sort of things that cross the line, things to keep an eye on and point out to the judge in the way of an objection if it arises. But I don't get too hung up on my opponent. With all due respect to my opponent, it's very rare that my opponent sort of snatches victory out of the jaws of defeat or something like that. If somebody is going to be a jerk and just not cooperate, won't tell you who they're going to call as a witness, then silly things, then I just treat them the same, and not they don't get any favors from me. It's if they want to be simply non-social, I like to interact during the course of a trial, not in an appropriate fashion. But if somebody is of the mindset that no, they hate me and everything I stand for, and they're going to treat me accordingly, then that's fine. I don't really let that get under my skin. I've sort of learned that over the years, and I'm dictating the pace of the trial. I bring the energy. I'm hopefully the person that the jurors are kind of, I'm looking forward to Mr. Salvi's cross-examination, or I want to show them how competent I am, how the charisma that I have, the energy that I bring, and so I remember a case I tried in an obstetrical malpractice case, a very bad brain damage. It worked out very well in a very conservative jurisdiction, I might add. And after the closing argument after my closing argument, defense lawyer got up for the hospital and said, well, in my 35 years of practice, I don't think I've ever heard a better closing argument. I turned to my associate and said, well, I hardly can object to that, right? And so that's the kind of atmosphere and feeling and energy I like to bring to the courtroom. Now, it's not about me. Don't misunderstand me. It's not about. I don't want the trial to be about me. I want it to be about my client, his or her struggles, how much the compensation should be. I want to be just somebody the jury, has credibility with, and is going to listen and be persuaded by what I have to say.
Mr. Salvi, there is, and this may be a stylistic difference. I've heard some personal injury attorneys say that with regard to medical bills, and you explained earlier that medical bills are essentially the plaintiff doesn't get any of that money that goes for medical bills. It's all paid to providers, chiropractors, doctors, neurologists, et cetera, for the rest of their life in many of your clients' cases. What do you think about the strategy of waiving medical expense, big medical bills, because it gives the defense attorney something to anchor to? So the defense attorney could stand up there and say, well, give them their medical bills. That's perfectly reasonable. We're willing to do that. And of course, the medical bills may not be that substantial. The substantial part is going to be the pain and suffering, harm to a normal life stuff, not the medical bills. What do you think about waiving those and then pushing on those other issues?
Yeah, no, we're a proponent of doing that. It's a judgment call depending on the amounts you're talking about. But oftentimes, yes, you don't want to be asking for big seven-figure amounts and then have your medical bills, be, $17,000. It kind of pales in comparison. But even if you have an amount that you decide is kind of a close call and you decide to introduce it, then your job is to point out the fact that that's not what this case is about. This is a given. This is kind of a throwaway, but they are deserving of it. But let me talk to you about what this case is really all about as you go into your argument with regards to the non-economic elements of compensation. It may not just be an anchoring. There may be other reasons. There may be somebody that's claiming lost wages, but future lost wages, but neglected to file tax returns. That's easy. And then you just have to, keep that information out. And so those judgment calls are made. I've done it frequently. And I think it's a good strategy oftentimes.
I read a book recently called Hitting the Bullseye. It's by the American Association of Justice, or American Justice Association. I forget the name of the civil lawyer group, but it's a book.
Association of Justice.
Thank you. They wrote this book about doing your own focus groups, and basically their argument is that a competent attorney who trains their staff in-house on how to do focus groups can do several for just several $1,000s, which for focus groups is very inexpensive compared to hiring an outside person to do it. And also the lawyer may be more experienced with the particular circumstances of the case and of the instant litigation, so that their focus groups may be superior to that of an outside firm. What do you think of that? Do you think that is a good strategy for plaintiffs' firms? I'm sure that would differ by the size. For instance, smaller firms might think that it would be good to do it in-house because it's cheaper. Larger firms may prefer to go with someone more established. What's your opinion on focus groups? How have you used them, and on this author's view?
Well, I don't think in and of itself an in-house focus group is a bad idea. It's not something that I would do. Number one, if you're focus grouping a case, and we'll oftentimes do it multiple times, it's because it's a substantial case. That doesn't mean it has to be worth 50 million, but it's a seven-figure case at a minimum. And to be honest with you, nowadays, in my opinion, trials are so costly, time-consuming, so full of angst that it's hard to justify almost cases that aren't at least seven figures in my judgment. Now you can't always be cutting your teeth on multi seven-figure cases, and And we, in our office, and we try a lot of cases, many of them are healthy six-figure cases. And then those are good results in those particular cases. But you know what? I'm not looking to save a few $1,000s on a focus group. I'd rather give it to somebody that knows what they're doing. They organize the logistics. They get the people. If they do, if they're competent, they get a good cross mix of people. They feed them lunch. They have all the logistics handled. And you just present the case. You're not worried about, did my assistant order lunch for everybody? And, is there one or two jurors that are kind of skewing the whole process? And, how do we pick this person? And, so I think it's better left to a third party that's in the business of presenting them. And we have some good people in Chicago. I also like the kind of virtual ones too. I like to kind of do a mix. And then, then you have to have realistic expectations as to, what to derive from a focus group. Things you didn't expect to be a big deal or a little bit more, you need to put more emphasis on. Something you didn't think was that important, turns out maybe it is. Or they point out things that, they realize, the focus group people realize the limitations of a focus group compared to a real life trial. And they can give you great insight in terms of, well, this is how I feel about this case, but what's really going to be crucial is the testimony of the plaintiff or this expert, or whatever the case might be. So I don't think it's a bad idea in and of itself, but it's not something that I would do. We're in the business of prosecuting cases, presenting trials. We're not in the business of presenting focus groups.
I think that's extremely sensible, given your firm's success and the resources that you must have at your disposal to tackle these very important cases that obviously require a lot of resources to be able to deal with. I think maybe that for smaller firms, it might be a good idea. It's funny, I'm actually going to be in a focus group next Wednesday for a personal injury case. I don't know whether I want to say it is a plaintiff side firm. If it was defense, I wouldn't do it. But my mom let me know about it. And so I'm going to go in and see, who they're using and how it works, and try my best to help them out. And also it'll give me an inside look as to my, the jury pool in Wyoming. I don't intend to practice here, but I think it's good knowledge. Let me ask you. So I talk to a lot of lawyers, and I try to pick lawyers that I think are the best of the best. And I don't do this out of any elitist sensibility. I really, I am not a real elitist guy. I was, raised working class from Cheyenne, Wyoming. I don't have that in me. But I'm trying to do it because I notice something in every profession, and not just every profession, but even recreational activities. The best people, what distinguishes the top 1% from the top 5% is these extraordinarily small differences, like a lot of very small things done right and even done perfectly. What are some of the things that distinguish? Because obviously the first three rules of trial advocacy are preparation, 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 as you've already indicated. Maybe the next three are investigation, investigation, investigation. But what, beyond the foundational, what are the advanced skills that lawyers have to take on, good lawyers, to become great lawyers?
Well, that's a good question, and it's a very important question and issue to address and discuss. In my field, and in our practice, I feel very strongly that our obligation is to provide extraordinary services to the client, not average run-of-the-mill personal injury result. When you hire us, the expectation is that you are going to get the best result, an extraordinary result. And then by that, I mean it may be 2, 3, 5, 10 times more than what would be recovered by someone capable, competent, handling a particular case. And the reason for that, in my opinion, is several things. Number one, you must possess a certain God-given talent to communicate, persuade, and it doesn't, it can come in different forms and methods and personalities and approaches. But there's certain lawyers that just have a God-given talent, and God willing, hopefully I possess that. I've been told I do, so I'm going to accept that. And so number two, you must possess an extraordinary competitive spirit and sense about a case. You must absolutely dread the idea of losing, because when you are very, very competitive, you just will do whatever is necessary within the bounds of ethics to not lose, in fact, win big. And how do you do that? With the God-given talent, you are undoubtedly the most prepared lawyer in the courtroom. And by that, I mean, you've not just memorized every deposition page, chapter and verse and what line and page and line it's on, but, you have the ability to, because, a trial is not going to unfold completely along the script that you anticipated. You're dealing with human beings, the judge, the witnesses, the jurors, the dynamics of a trial. And so you have to be prepared to adjust on the fly, on your feet at a moment's notice with regards to those dynamics. And again, you're much, you have to be smart but the lawyer that, is the most prepared person in the courtroom. Well, once I'm there, my confidence level is, this much higher. And I'm at ease, not in the sense of, letting, think you're very attuned to what's going on at every moment. But, you're present, you're able to really deal with almost any situation that arises in the appropriate fashion. So that's what I would say. Now that said, you can't be so afraid to lose that you're unwilling to go to battle and face the prospect of losing, as hard as that may be, as gut-wrenching as that may be, because then you'll cave in. So people say, well, Salvi, if you give me because I'm the boss now for many years, I get to pick and choose. And so naturally, I pick and choose the most compelling cases, both from the standpoint of liability and damages. And people say, well, if I had a quadriplegic and a truck accident like that, But I said, well, yeah, but are you willing to turn down 30 or $50 million? Then it's just a different kind of pressure, and so you have to be, you have to be willing, you have to be fearless, and you must trust your skills and your abilities. You must trust that you will deliver a win. Even though the defense lawyer from beginning to end is saying, if he doesn't prove his case, would you, not guilty, or for award a fraction of what Salvi suggests. You have to be pretty fearless and trust your skills and your abilities that you're going to deliver. And so I would say God-given talent, tremendous competitive spirit. You're going to do whatever is necessary within the bounds of ethics to win, but not be afraid to lose. And you got to think big. Think big. Do not let a judge, or certainly not a defense lawyer, tell you that you're crazy, or that you can't deliver. If I, like I say, defense, if I listened to you, during the course of my career, I wouldn't achieve, anything anywhere near, the success that, we've had. So you determine what you think the value of the case, and the verdict that you mentioned. Once I had an appreciation for the struggle the plaintiff was in, then I thought, well, I'm going to voir dire on 100 million, but then I decided that I'm going to voir dire on approaching 200 million. And I'm glad I did. And did people think we were nuts? Yeah, and including the judge and the AIG, the insurance company, but we delivered.
You showed them.
Yeah.
Mr. Salvi, that was a great answer. I sense that you are a fellow traveler when it comes to the desire for excellence. I have seen firms that are happy providing good, and that's not enough. It's not enough in criminal, especially it's not enough in criminal defense. Everyone thinks your client's guilty. You can't take easy cases in criminal defense. Every case is a hard case. And it, as you said, it's not true in civil law with respect to personal injury either. And the courage that you have to have, I've heard it, I think Jerry Spence said that courage doesn't mean that you're not afraid, because as you said, you have to be afraid, you have to fear the loss, but it means that you proceed to battle despite the fear that you feel. And I think that getting, as you said, a kind of emotional intelligence and a knowledge of yourself and a trust in yourself and a confidence, that's a really, really big part. And as you said, how do you get a $200 million verdict? You turn down the $30 million offer. And it is easy for other lawyers to say, well, I could do that if I was, was renowned enough to attract these serious cases with clear liability. But as you've also stated, you have to have the courage to turn down the offer. And I'm thinking about attorneys that have put mortgages on their homes, that have taken serious financial risks, and that demonstrates. And I don't know that I would do that, and that I would encourage others to do it, but it demonstrates a serious amount of courage and confidence. And some of those lawyers, including some of the big tobacco lawyers, they did very well. It's a really powerful answer, Mr. Salvi. I wanted to ask you, with respect to continuing to be a lifelong learner, do you make it a priority to continue to stay up on the science, to continue to stay up on everything related to catastrophic injuries, to go to the CLEs, to give your own CLEs. How do you try to stay a lifelong learner so that you can provide the level of excellence that you obviously strive for?
Yeah, all of the above. I'm an avid participant in CLEs, and now you get some gray hairs. I end up presenting more than participating, but that requires significant preparation, because I really take it seriously to present meaningful information to the participants, the attendees, and while trying to entertain at the same time. And after 40 plus years, still nothing gets my juices flowing like a new case that comes in, and maybe a new medical procedure, or some aspect of how a certain injury took place. We recently accepted a case where 3 men were tragically killed when a demolition company let some errant explosive devices not be accounted for, and it resulted in the tragic death of three young men, all of whom had families. And so learning about a new thing, in my case, explosives, something I hadn't had a lot of experience in. I love medical malpractice cases. Everyone is a little bit different. It's a very, very important skill to possess. I'm proud to say that, we have in our firm some of the best malpractice lawyers in the state, because it's a special skill. So I think no matter what your experience, no matter what your track record, you never reach a point in time in your professional career where you figure, well, I've learned it all. I don't really need to be learning anymore. People just need to listen to me and what I have to say. The day I start doing that is the day I'm in trouble, and so that isn't our attitude at all. In fact, quite the opposite. And as we've talked about, as I remind all our lawyers, their obligation is to provide extraordinary results. That is the reason as someone comes to our firm or a lawyer refers a case to our firm. That's the obligation we have, and we take that very, very, very seriously.
Great answer. I think that it's, I'm learning as the more, so I have a huge stack of books in my room in Chicago and here in Cheyenne, where I am for Thanksgiving. And I'm not going to say that I've read all of them, but I intend to. And the reading to be able to successfully cross-examine a medical expert, as you know, is just monumental. Like in criminal law, you almost have to know how to conduct an autopsy yourself to do it properly. It's very involved. And so I admire lawyers who are not afraid to say, I don't know, let's find out. And with respect to that, there was a lawyer by the name, I mentioned Rex Paris, and a lawyer by the name of Roy Black, who's in criminal defense, does limited civil work. Both have suggested that criminal defense attorneys should abandon the trial advocacy texts that they've been reading and start reading books on education, as in how people learn information, how they take it in, how it's best presented, the peer-reviewed stuff, and then also marketing. How do companies persuade us to buy their products with very limited information? And honestly, what's an advertisement other than like putting a watch or a product next to something else and creating an association? You put a Jeep next to a horse, and suddenly you've got the mythology of the frontier spirit attached to that Jeep. That Jeep doesn't have anything to do with the horse. I should know. But I think that I have a reading list if you're interested that I can send you. It's not mine, didn't originate with me, but I picked it up from a few lawyers, and I'm happy to send it. In fact, I think I'll share it more widely. Mr. Salvi,
please, I'd love to see it.
Yeah, absolutely. In the remaining time we have together, What would you say, and I know that it's very difficult to narrow this down, but what would you say was your most difficult case? And what was the problem with that case that made it difficult, or the bad fact, or whatever it happened to be? And then how did you overcome that obstacle?
Well, I would say that probably the most difficult case I had was I represented a gentleman that he took out a this was a while ago. This was in the 90s. There was a Cadillac sports car that was kind of popular at the time, and he borrowed it for the weekend, thinking about telling the salesperson he's thinking about buying it, and somehow he persuaded the salesman to let him have it over the weekend. Well, in the meantime, he took out one of his friends on a Saturday night, and they went out and, were overserved. And he was a little worse than his friend, so he let his friend drive. And his friend, driving too fast, was unable to negotiate a curve, went off the road, hit a tree, killing his friend and causing a spinal cord injury to him. And it just so happened that the dealership provided a very large insurance policy for anyone operating the vehicle or that had permission to operate the vehicle. So one of the difficult things was, number one, the issue of contributory negligence on the part of my client. In addition, the defendant was not the dealership. The dealership had they just provided the coverage to any permissive user. So the defendant was the estate of, and his widow, in my case, went to trial, the widow, the grieving widow. And of course, as you know, the jury has no idea as to, what insurance there is. And so, as I think I mentioned earlier on in the discussion, that in this case, my client, nice guy, but a little rough around the edges, and had a little bit of a checkered past, and he was in the construction business, although it was a cash business. And so he was telling me, as a result of my injuries, I lost a lot of cash. I said, well, would you tell the Internal Revenue Service, all the cash? Well, no, I said, well, we can't claim that. We can't tell the jury, believe us on pain and suffering and everything else, but we're lying to the federal government. We can't do that. So we're not going to make that claim, but you have a serious injury. Fortunately, he had the most lovely wife who somehow put up with him, and, had a loss of consortium claim. And so, we were offered pretty good money in spite of some of the problems with the case. And I lost a lot of sleep. But before he was to testify, if I prepared him once, I prepared him 100 times. I said, they're going to try to make it seem like you're out for this joyride. And according to what you tell me, you let the guy drive the car because you thought that was appropriate. And, you don't have control of the steering wheel and the gas pedal. And so, what it is what it is. And so as I put him on the stand, I said, okay, can you tell us what happened? And the first words out of his mouth were, well, I thought we're just out for a joyride. And of course, my heart goes into my stomach. And fortunately, we kind of grinded through that. And I quickly put his wife on the stand and she was just delightful, kind of rescued the day. The verdict was an 8-figure verdict, minus 30% for his contributory negligence, which I was happy to accept under the circumstances. But I tell you, it was a lot of sleepless nights, especially as we waited for the verdict for a long time. But it worked out. But I remember fearing that the jury was going to really, send them a very bad message. But we were able to do enough things to pull it out. And it was a long time ago. So I remember too, I was just coming off literally back-to-back trials. I was just coming off a very large verdict in Lake County, Illinois. This one happened to be in Cook. And so it helped me professionally, because I literally went from one trial to the next. And so it was good for my professional career, got a good buzz going in the courtrooms.
That's excellent. I've heard that waiting for a verdict is like waiting for a baby that's never born. And it's just incredibly stressful. And I'm sure that I will react similarly. Mr. Salvi, it has been more than a pleasure to have you talk to me, really. And I thank you very much for your contribution to my program. And I hope that we can stay in touch in the future.
Absolutely. It was a pleasure, Austin.
Thank you.